Everyone, welcome to Study Time Anytime, the YouTube channel. And today our lecture is concerned about Civil Procedure Code. Now, you all know that in Civil Procedure Code there are two parts. One is section and other are the orders. Now, in order to learn the orders, you have to keep in mind we will just take a brief outlook of all the headings, and these headings are taken from the app that is available from the Play Store under the name of Civil Procedure Code at Vulcan app. And now you may see that these are the names of the orders. These are generally headings of the orders. And now this we will discuss about every order in a brief manner, and we will try to learn these all. Number 1, the order number 1 is the parties of suit, and it is mainly concerned with the parties which who will be the plaintiff, who will be the defendant, plus who is placed first, that is whose name will be placed first, whose name will be placed later, who will be the plaintiff, who will be the defendant. This is the order 1. Then order number 2 is the frame of the suit. Frame of the suit is very much easy. You may see that frame of the suit, every suit as far as ever practical be framed as to it is about the how to write, it is about drafting the suit at all. Then order 3 is the recognized agents and pleaders. Now see, there is a very sequence of this. First they have told that there is a plaintiff. In second, they has told that he will file a suit in a manner. And in third, now they are saying that if the plaintiff is not available, then he may sue through agent. He may sue through the agent, or the pleader is given the attorney to represent the plaintiff or the defendant also. Then the fourth is the institution of suit. Now institution of suit carries mainly some points like suit to be commenced by plaint, register of suits. So these types of points, just a small order this is. Every suit shall be instituted by presenting a plaint to the court or such officer as it appoints on the behalf, and there will be register who will take a record of it. So this is order 4. Then there is order 5. Once you have filed the suit, now another sequence. Number 1, plaintiff has filed the suit. Now suit is being represented by the agent, and that has been registered. Now the suit is registered. There is a plaintiff. He has framed suit, or he is represented by agent. He has registered in court, and now he will send summons to other party. From 5, now we come to next 5, that is pleading generally. Pleading generally has further rules and sub rules that deal how the pleading should be there, how it may be written, what are the different options. Like the very famous that is mostly asked in the exams is order 6 rule 17, that is amendment in the plaint. Amendment in plaint, and it means that once you have filed the suit, then a plaintiff wants to amend that or add some relief, then he under this order is able to file an application to the court, and with the permission to the court he can amend in the plaint. We will discuss all these in detail when we will cover these lectures in by order. Next is order 7, that is plaint. Plaint is the, you can see, the plaint is containing the particulars to be contained in the plaint, like the name of the court, the name and description. So here the motive of our reading these names, these orders, these headings is just to make a series, make a story in the mind of the students, that these all are made in a general manner, in a way the suit is filed, in a way the court follows the procedure. And now we have come to order number 8. Now if the plaint is ready, then after filing the plaint, who will come? The defendant, on receiving the summons, and on receiving summon he will file a written statement, or he may go for set off. There is one F less in this, or it is counterclaim. Written statement is the reply to the plaint. Set off is the set off is balance the mutual debts. Now example of it is, if A sues that he is owing or has lent 50,000 against B, and B will say that 30,000 has been lended to A once, then the amount remaining will be 20,000. So these 30,000 has been set off. The 30,000 has been set off. Now the counterclaim is similar thing, that there is a party who is saying that there is a property, say, of 500 square yards, and A has filed the suit against 4 other persons who all claim 100 square yards in this property. So if there are 5 shareholders, each having 100 square yards share, then on filing the suit, the other 4, say B, C, D and E, they appear, and they also claim the same portion of land from this entire property, 500 square yards. So that is the counterclaim to the suit filed by A. A has said that I have the portion, or I am the owner of the portion of 100 square yard out of 500, and this, say, 500 is in possession of B alone, and other C, D, E will, on reply, on giving written statement, they will file a counterclaim to this, that yes, we also are having a share of 100 square yard of C, D, E and then B and A. In this way the court will decide the matter as on the merits. Then order 8, that we have. Order 9 is the appearance of the party and consequence of non-appearance. So this is the order which is mostly concerned with the how the parties which appear, and if the plaintiff is appearing, the suit will continue and defend. If plaintiff is not gonna appear, the suit will be dismissed in default, and if defendant will not appear, then what will happen? If defendant will not appear, then he will be proceeded ex parte. And similarly, if an ex parte decree has been passed against the defendant, then he has to set aside that decree, and that is mentioned in order 9 rule 30. Now further, there is order 10, that is examination of the parties by the court. Now this order is the very simple, that is examination of the parties by the court, ascertainment whether allegation in the pleadings are admitted or denied, oral examination of the party or companion of the party. So these types of things are defined in this order. Then order 11 is regarding discovery and inspection. In discovery and inspection, the court is empowered to give interrogatories. The plaintiff or defendant, by leave of court, may deliver interrogatories. They have the power to ask questions in the form of interrogatories. So this is order 11, discovery and inspection. This is for search of things, or when there is a LC is appointed, local commissioner is appointed to go somewhere and take the with evidence or to record the statement of someone. Then the others or defendants may give a list that of questions that is called interrogatories, and the same questions are then asked to the person to whom the local commissioner has appointed or to whom the interrogatories has been marked. Then admission. Now admission is a very important thing. It is order number 12, which is very important. What the thing you have admitted is very crucial in every case. Once you have admitted, you are stopped by your own acts. So notice of admission of case. Any party to the suit may give notice by pleading or otherwise in writing that he admits the truth of the whole or any part of the case or any other party. So notice to admit documents. So these all things are covered in this order 12. Then order 13 is production, impounding and return of the document. Now you need to know production, impounding and return of the document. Production, you are relying upon a document. Here you are relying that this I am the owner of property by way of sale deed. So the other party, by application under this order, may ask you to bring that sale deed. So this is the production of a document that is mentioned in this order. And then impounding. Impounding is the term that is used to impound the documents in the court. For example, one is saying that he has agreement to sell in his favor. Agreement to sell in his favor, but the plaintiff is saying that he is ready to and ready and willing to perform his part of the duty, but other party is not performing and he has filed a suit of specific performance, and that document, that agreement to sell, is not having the proper stamp. For example, if you need the stamp of 500 for a proper agreement to sell and there is only a 25 rupees stamp on this, then the court may impound the document. However, under Stamp Act there are other provisions that there will be penalty of up to 10 times, then your document may not be impounded, and in case the document is impounded, it cannot be read in the evidence. And third is the return of the document. So this is also a part of CPC. Like once you have submitted any document, now you need that back. You have given that document for evidence or someone else, or you now need that document back, so you need to apply for this and the court has the power to return that document. Order 14, settlement of the issues and determination of the suit on the issues of law or on issues agreed upon. This is the part of the court which in the proceedings one has filed suit. The suit filed, written statement has come. Now the court will see that what are the facts in issue, what are the issues of law, what are the issues on fact, and one can also add any issue by filing an application to determine the same by praying to the court that this issue may also be decided by the honorable court. Then order 15, disposal of the suit at the first hearing. This thing I don't think that normally happen, that if the court find that there is no issue between the parties either of law or of fact, then the court will dispose of the matter at the first hearing. Next, there is order 16 to 20. Now summoning and attendance of the witness. This is about the witness that will come, how to summon them, how to mark their attendance. And then order 17, there is adjournment. Adjournment, that today we have filed the written statement. Now there will be adjournment for deciding any other application that is pending before the court. So these are some grounds that are mentioned for adjournment, that when hearing of the suit has commenced, it shall be continued from day to day until all witness. And then second point is no adjournment shall be granted at the request of the party. And C is the pleader is engaged in another court. Sometimes there is a plea that my pleader is engaged in some other court, kindly adjourn the matter because he will not be able to come in this court, he is busy in session court or in a murder trial. So this is not a ground for adjournment. Then illness of pleader is or his inability is the same type of question matter. His inability is not a ground of adjournment. And even where a witness is present in court but the party or the pleader is not present, so there are even scope that you will have to face some cost, and it is upon the court how much cost it want to file upon you for the adjournment. This is about order 17. And then order 18 is the hearing of the suit and examination of the parties. This is related to the how to hear the suit, how the suit will run in the how the suit will continue in the court, and the examination of parties. There, in Evidence Act there is first examination in chief, then there is cross examination. So these are all procedures are similar in every code. And then affidavits, everything you file in the court it is in the form of affidavits. Like affidavit, if you have to give any written statement, then you have to give an affidavit along with that. Further, if you want to give any evidence, that is also given in the court in the form of affidavit. So affidavits are covered under order 19. Then there is order number 20, judgment and decree. So there is a difference between judgment and decree. Decree is the final decree sheet that is made. The definitions of these are given in the section part of the CPC. In short, the decree is a final adjudication. Judgment is the detail of the order, why this adjudication have come. Now the order 21. Order 21 is the execution of the decrees and orders. Now you have received a decree in your favor. For example, you have filed a case for possession of shop. There's a shop, you are the owner, B was the illegal occupier of the shop. You filed a case suit for possession. A wants the possession of this property and want B out of it. The court will allow your possession on merits, and then you will execute on the decree. Court has given you the decree that yes, A is legally able to get possession, is legally able to get that possession. Now what the court will do? Court will do nothing. You have to file an execution application before the same court or to the concerned court of that area, and then court will appoint a bailiff. The bailiff will go along with you and will get this premises empty, and you give the empty possession to A. So this is the entire procedure. Then A will come back to the court after getting possession and record his statement in the court that yes, I have got the possession of the shop and the decree has been effected positively, and then the said application is disposed of by the court. Then there is order 22, that is regarding death, marriage and insolvency or parties. Then the death someone died, who will now represent, marriage, in case of marriage, who will come, insolvency. So these are covered in order 22. The main concern is you just read heading. You must know that what area. If you are talking about death, the death is covered under order 22. If you are according or you are concerned about the payment of the court, you have been fined, now you want payment into the court, then this is order 24. If you want that how pleadings be made, then order 6. So these all have to be in your mind. If you know the orders, then you will able to learn the rules. So you have to keep all these things in mind. So next is order 23, that is withdrawal and adjustment of suit. There is power given by the court. The plaintiff can withdraw the suit at any time. Then order 24 is payment into the court. There is any payment that is to be made in the court, then it can be made in the court under order 24. And last is the 25th, security for the cost. So what is this detail? I will tell you in this, that when security for cost may be required for plaintiff at any stage, the court may either on its own motion or the application of the defendant or the plaintiff for the reason. So there may be some reasons that plaintiff will go out of India, or he is just harassing the defendant, and the court believes that there are such circumstances that the plaintiff needs to require due to deposit a security, then the security is deposited here. So this is the end of our video. We have just covered order from 1 to 25. The remaining orders will be covered under the next video. Thanks for watching. God bless you all.